Welcome back to The Deep Dive. Today, we're wrestling with a legal saga that, it spans 3 entire decades.
It does.
It's a case so complex, so full of these procedural knots, that it perfectly illustrates the agonizing trade-offs you find in the American justice system. We're talking about Rodney Alcala.
The so-called dating game killer.
Exactly.
And our focus today isn't really the standard true crime narrative, the hunt for the killer.
Yeah.
Our mission is to really understand the labyrinthine legal war that was waged after he was caught. The story of Alcala is a masterclass in how procedural missteps, these endless appeals.
And then, finally, the relentless march of science.
Right. How all of that defined the search for justice in a capital case.
We've put together our sources for this: court transcripts, journalistic accounts, some really deep legal analyses to trace this tortuous path.
Very tortuous path.
We're tracking the trials, the verdicts, the 3 major overturns, and then that final definitive conviction in 2010.
It's really an exploration of the justice system under just immense stress. You can see it struggling under the weight of this case.
And a very intelligent, very manipulative defendant.
Extremely. It all started simply enough, right? The arrest for the kidnapping and murder of 12-year-old Robin Samsoe, Orange County, 1980.
But that moment, it wasn't an ending. It was more like the firing gun for a 30-year legal marathon.
Exactly.
So let's drop into that Orange County courtroom, 1980. Alcala is 36. He's standing accused. And the atmosphere is just electric.
Oh, absolutely. It's charged with this public and media frenzy, mostly because of Robin Samsoe's age, and then the sheer horror of her disappearance.
And he's facing the death penalty.
The gas chamber at that time. And his demeanor. It was just chillingly consistent. He was calm, focused, intelligent.
This bizarre contrast to the monster he was accused of being.
Really was. But the prosecution, they had a fundamental challenge. Their case was strong, but it was built almost entirely on circumstantial evidence.
And that's where the legal friction starts, right? To convince a jury to send a man to his death, you need proof beyond a reasonable doubt.
Absolutely.
So let's look at the core evidence they actually presented.
Okay, so it started with establishing opportunity. They had some really powerful eyewitness testimony.
Right.
2 young women, Bridget Wilverd and Jackie Young. They confidently placed Alcala at Huntington Beach, actually interacting with Robin just hours before she vanished.
So that establishes the link. He was there.
It establishes presence, a crucial link.
And then we move to the really emotional evidence, the kind that connects the raw grief of the family directly to the cold facts of the case.
The gold ball earrings.
Yeah.
Robin's mother, Marianne Connolly, had the just agonizing task of identifying them.
They were found with his things.
Found among Alcala's possessions.
Yeah.
Now, the defense, they rightly argued that, look, gold ball earrings were a super common accessory in 1979. But when a mother identifies a small, personal item belonging to her daughter in the possession of the man accused of killing her, that visual, that emotional identification is profoundly difficult for a jury to just ignore.
Even if it's technically circumstantial.
Exactly.
And then there was the photograph. The piece of evidence that, as our sources say, really elevated the case from just a difficult circumstantial argument to something deeply sinister.
It was a picture of a smiling, alive Robin Samsoe.
Wow.
And it was discovered deep within this trove of hundreds of photographs of young women found in Alcala's Seattle storage locker. This was more than just evidence. It was like a psychological key.
The prosecution had to have known how powerful that image was.
They did. It suggested a trophy collector, someone who documented his victims.
The source we looked at used this really powerful, disturbing metaphor. It described the photograph as a receipt for her life.
Stamped by her killer.
Chilling. It basically turns the photo into an admission of guilt.
It shows intent, possessiveness. It transforms the case from one of simple proximity to premeditated malice.
But okay, despite all that emotional weight, the defense still correctly highlights the legal weaknesses.
They do. There was no direct physical evidence linking Alcala to the body. No fingerprints, no blood, no fibers.
And certainly no DNA.
No, DNA wasn't even a thing then. So the defense argument was simple.
The earrings are common. The photo is just part of his job as a photographer.
And coincidence does not equal capital murder.
The prosecutor's frustration must have been just immense because they knew the full story. They knew who Alcala really was.
They knew he was a serial predator.
Mm-hmm.
But this is where you see that critical judicial safeguard kick in. The moment the system, in prioritizing fairness, potentially puts the truth at risk.
And the judge makes this landmark ruling that would ironically launch 3 decades of legal warfare.
Yes, the judge adhering very strictly to the rules of evidence, rules that are designed to protect the defendant from unfair prejudice. He barred the prosecution from introducing evidence of Alcala's prior bad acts. Specifically, the attacks on Tally Shapiro and the 13-year-old Julie J.
Let's unpack that for a second, because this is so central to how the U.S. justice system works. Why, in a case where a pattern seems so essential, would a judge restrict evidence that shows the defendant has done similar things before?
It all comes down to a core principle. You must be tried only for the crime you are currently charged with.
Right.
Introducing evidence of prior crimes, especially violent sexual assaults, is seen as highly prejudicial.
The fear is the jury just says, well, he's a bad guy, so he probably did this too.
Exactly. Instead of judging the evidence for this specific case objectively, the goal is to ensure the jury focuses solely on the Samsoe murder facts, nothing else.
So this ruling meant the jury saw what our sources call an artificially sanitized version of the defendant.
That's a perfect way to put it.
They saw a man accused of one horrific crime, not a serial predator with a proven history of targeting young girls.
Precisely. And the prosecution must have felt like they were arguing with one hand tied behind their back. They couldn't establish the pattern of predation that was so essential to understanding how Alcala operated.
But even with that limitation.
Even with that, the circumstantial evidence, the eyewitnesses, the mother's painful identification, and that trophy photograph, it was powerful enough.
The verdict was returned, guilty, sentence, death.
And for the Samsoe family, this was a moment of, our source says, crushing yet triumphant finality. They endured the trial, they saw the verdict, they believed justice was done.
But the gavel had barely settled.
Before Alcala began meticulously scrutinizing the entire process, just searching for that one technical flaw that would give him another chance.
And he found it.
The moment Alcala hit death row, he transformed. The sources really emphasize this. He leveraged his high IQ and all the time in the world he had at San Quentin to become an obsessive student of the law.
Right, he basically becomes his own lawyer.
He acted as his own co-counsel through a lot of it, filing motions, appeals, petitions, with incredible frequency. He wasn't just relying on his public defenders.
He was actively hunting for procedural errors.
That was his goal. It wasn't about proving his innocence. It was about proving the process that convicted him was flawed.
And 4 years later, 1984, the California Supreme Court delivers this massive blow to the Samsoe family. They overturn everything.
The conviction and the death sentence, gone.
So we have to step back and look at the legal reasoning here. The court didn't say the evidence was insufficient?
No, not at all.
No.
They overturned the case based on a very specific, very nuanced legal finding. The trial had created a fundamentally unbalanced proceeding.
Okay, that phrase, fundamentally unbalanced proceeding, sounds incredibly technical. For us, for the listener, what does that actually mean in practical terms? How did the judge cause this imbalance?
Well, it boils down to a failure of judicial neutrality, really. It's about the constraints placed on both sides. The court identified 2 conflicting errors made by the trial judge.
2 errors.
On one hand, the judge precluded the defense from exploring a particular alternative suspect theory. That's the right to do that.
So the defense couldn't argue, hey, if it wasn't Alcala, maybe it was this other person.
Correct. But here's the fatal balancing act. While restricting the defense, the judge also restricted the prosecution by barring the prior bad acts evidence.
I see.
So the Supreme Court basically said, look, if you constrain one side by limiting their ability to present a complete case, you have to grant them latitude somewhere else. Or at the very least, you can't simultaneously constrain the other side in a way that creates this totally artificial view of the truth.
So by trying to be fair, by keeping out those prejudicial prior crimes, the judge unintentionally created a trial that actually prejudiced Alcala's right to a fair hearing.
Exactly. Because the jury wasn't allowed to hear all the potentially exculpatory evidence the defense wanted to present, even if that evidence was pretty weak.
So the whole trial record was just deemed too artificial.
It was. And the system's commitment to process, to due diligence, it trumped the certainty of the verdict.
Which meant a mandatory reversal. And the agonizing order for a new trial.
And this is where the emotional cost just becomes immense. For Robin's mother, Marianne Connolly, that ruling meant reliving the entire investigation, the autopsy reports, the crime scene details.
A painful testimony.
For a second time. We talk about the legal burden, but The psychological burden on victims' families, this perpetual re-traumatization, it's just staggering.
It's the inherent tragedy of due process in these capital cases, isn't it?
It is. The system is designed to bend over backward to ensure no innocent person is executed. That diligence, that focus on every single technicality, that's the system's strength.
It's how we guard against error.
But the price of that diligence is delay. And that delay is paid for in the agony of the victim's survivors.
So despite this crushing emotional weight, the state gears up for the 1986 retrial.
And the whole painful process just repeats itself. Same courtroom, same core witnesses, same evidence.
But there was a key difference this time.
There was. In 1986, they mitigated that previous error. The prosecution was allowed to present some limited evidence of Alcala's past crimes. Still heavily restricted, but
It was something.
it was something. They could argue that pattern of predation a bit more effectively.
And the result was the same. Guilty. Second death sentence.
The gavel bangs a second time. But our sources describe the sound as hollow.
Because everyone involved knew this wasn't the end.
They knew the true battleground was still the appeals court. And for Alcala, it was just back to the law library. The war was just getting started.
So as the case drags into the 1990s, Alcala's appeals are moving up the ladder from state courts into the federal system. And while he's fighting for his life legally, he's also engaged in this bizarre side project that just perfectly captures his profound manipulative narcissism.
Oh, absolutely. From the confines of death row, he starts writing a book, a vanity project.
With the title, and you can't make this up, our source calls it Staggering Audacity.
You, the jury.
You, the jury. The idea that a convicted, twice-sentenced murderer would presume to lecture the public on the law and his own innocence is just, it's astonishing. What was in this thing?
It was over 100 pages. It's his rambling, self-aggrandizing treatise just aimed at painting himself as the victim.
A victim of what?
Of an irrational, emotional justice system. He casts himself as the misunderstood intellectual, the artist persecuted for his genius.
This isn't just about denial. This is about control.
Completely.
He couldn't control the trial outcomes, but he could try to control the narrative around them.
That's it, exactly. He called the families, the police, the prosecutors, the mob.
The mob.
Yeah, driven by vengeance, not logic. And he lectures his imaginary jury on the logic of his innocence, demanding they ignore the, quote, emotional theatrics of the prosecution.
And he specifically tries to dismantle the core evidence against him, right? The photo, the earrings.
Oh, yeah. He claimed the prosecution's case was a house of cards built on coincidence.
A house of cards.
For the photograph of Robin, he wrote that as a professional photographer, it was totally routine for him to take pictures of subjects. Finding a picture of her was just a statistical anomaly of his trade.
He's rejecting any idea that it was a trophy.
Completely. And this writing is so crucial because it gives us a direct window into his strategy. Always manipulate the facts to fit his narrative of persecuted innocence.
So while he's writing the self-serving manifesto, the clock is ticking, and the appellate courts are still at work.
They are.
And in 2001, almost 2 decades after the first overturn, the Ninth U.S. Circuit Court of Appeals delivers the second legal earthquake.
They overturned the conviction. Again.
Unbelievable.
And this reversal, it wasn't based on that old unbalanced proceeding argument. It cited 2 primary issues, and they were rooted in evidentiary standards that were evolving really rapidly at the time.
Okay, what was the first issue?
The court found that the trial court had improperly allowed the testimony of a jailhouse informant.
That's always a sticky area in criminal law.
It's inherently problematic. These individuals often have huge incentives to lie, reduce sentences, better conditions, whatever. The Ninth Circuit determined that the way this testimony was admitted in Alcala's case, it compromised his right to challenge the reliability of that witness.
So the fear is that the state effectively bought testimony rather than relying on objective evidence.
That is the core concern, yes. And the second issue the Ninth Circuit raised was even more reflective of the changing legal landscape. It had to do with forensic science.
Okay.
They found Alcala's defense was ineffective for failing to adequately challenge the hair analysis evidence.
Ineffective counsel.
Yes.
Let's talk about that. By the early 2000s, microscopic hair analysis, which was a standard tool in the 80s, was being reevaluated. Why was it suddenly seen as less reliable?
Well, back in the 80s, a forensic scientist would literally look at a hair from a crime scene under a microscope, compare it to a sample from the suspect, and claim they could see if it was a match.
Based on what?
On characteristics like color, cuticle patterns, things that were really subjective. By the 2000s, the scientific community realized this method just lacked the statistical precision of newer methods, like DNA.
Right.
And numerous studies and later exonerations show that hair analysis often led to false associations.
So the Ninth Circuit recognized this scientific shift. They argued that because the hair analysis was used as connecting evidence and its reliability was now seriously in doubt.
The defense counsel's failure to bring in their own experts to challenge that science amounted to a failure to provide effective counsel.
So it's a violation of his Sixth Amendment right.
Correct. The court found that if the defense had done its job properly, that unreliable hair evidence might have been excluded, and that could have potentially changed the outcome.
So once again, the solution is the same.
Reversal. And a third trial.
I mean, just think about that consequence. In the painstaking effort to make sure the accused gets every possible protection, the system seems to have forgotten the victims entirely. Marianne Connolly is in her 60s now.
And she's forced to confront the prospect of a third trial 20 years after the first one was supposed to be final.
The weight of that procedural effort is just tremendous.
It really is an illustration of the tension between legal perfection and human closure. Every time the system found a flaw, however technical, it restarted the trauma for the survivors.
But while the courts were moving so slowly,
Science was preparing its final, unassailable answer.
so as the state is preparing for a third attempt to convict Alcala for the Samsoe murder, a whole new strategy emerges. And it's largely because of the scientific revolution that had happened since the 80s.
Right. The Orange County BA's office, led by Tony Rakakis, they recognized that just relying on the same old circumstantial evidence from the Samsoe case.
Which had already been overturned twice on procedural grounds.
Exactly. It was risky. So they made a really bold strategic decision
Yeah.
that would consolidate.
They weren't just retrying Robin Samsoe. They were using this new science to charge Alcala with 4 other murders that happened during his killing spree from 77 to 79.
Jill Barkham, Georgia Wixted, Charlotte Lamb, and Jill Parenteau.
This was the mega trial.
It was. And by consolidating these 5 cases, the prosecution, led by Matt Murphy, could finally show the jury that undeniable, horrific pattern of predation that the previous courts had artificially constrained.
They could frame him not just as a possible killer, but as a proven serial murderer.
But the real game changer in the 2010 trial was the tool that just didn't exist for the first 2 tries: DNA testing.
This was the gold standard evidence, the thing that could go beyond circumstantial links and subjective interpretation.
The prosecution's core argument just shifted entirely. It went from eyewitnesses and emotional jewelry IDs to forensic scientists on the stand presenting hard data.
DNA provided the objective link that had been missing for 30 years.
He did.
Let's dive into the specifics, maybe focus on the Charlotte Lamb evidence because that really established the certainty they needed.
Okay, so in the original investigation of Charlotte Lamb's 1978 murder, biological evidence, a semen stain, was recovered from the crime scene.
And for decades, that evidence was just sitting in storage.
Preserved, waiting for the right technology. By the 2000s, forensic science was advanced enough to develop a full DNA profile from that decades-old, potentially degraded sample.
And when they compared that profile to Alcala's known DNA sample,
The result was unambiguous. The key was the sophisticated techniques they used.
so how do they get usable DNA from a 30-year-old stain?
Well, they used techniques like PCR, polymerase chain reaction, which is basically a molecular copy machine.
Okay.
So even if the sample is tiny or partially broken down, PCR amplifies these specific regions of DNA, they're called STRs, that vary widely between people.
So by analyzing enough of those markers,
They create a highly specific, unique profile.
and the result was the statistical proof that just stunned the courtroom.
It really did. The forensic scientist on the stand provided the probability, and it was staggering. The chance of selecting an unrelated individual at random who could be the source of this DNA.
Was approximately 1 in 190 quadrillion.
1 in 190 quadrillion.
I mean, that's just a statistical way of saying absolute certainty.
It is. It moves the argument beyond reasonable doubt entirely. It's a biological signature. You can't argue it away as coincidence or a photographic hobby.
And this technology became the scientific voice of the victims.
It did. This same definitive evidence also connected him to Jill Parenteau and the other victims in the case. And the consolidation was brilliant because it established this clear, unmistakable pattern.
5 women killed in a similar way, often after being photographed.
With definitive biological evidence linking Alcala to the group.
So when you're faced with that level of scientific certainty, Alcala's defense strategy just it crumbled.
It did. They were reduced to relying on his old playbook. He's just an eccentric artist. But their main technical challenge focused on sample integrity.
They argued that because the samples were decades old, there must have been contamination or degradation, trying to inject doubt into the science.
It was their last-ditch effort. But the forensic scientists were ready. They meticulously detailed the chain of custody, the preservation protocols over 30 years.
Then they affirmed the results.
They affirmed that the DNA profiles they got were clear, unambiguous, and reproducible. Degradation might affect the amount of DNA you can get, but it doesn't affect the accuracy of the profile.
The science held firm. There was no scientific doubt as to the source.
So that narcissistic narrative Alcala had so carefully crafted over 2 trials and 2 decades of appeals.
The misunderstood intellectual.
The victim of emotional overreach. It all just dissolved under the weight of quantifiable, reproducible facts.
Prosecutor Matt Murphy's closing argument in 2010 really capitalized on this shift. He used the DNA to give a voice to the victims.
It was a powerful moment. He argued that Alcala had hidden behind legal technicalities and manipulative words for 30 years, but now...
Science has now given those ghosts a voice.
That phrase just captures the culmination of the entire decades-long fight. The DNA left behind by the killer became the combined, objective voice of all 5 women, pointing directly at Alcala and finally demanding final, definitive accountability.
The power of that consolidated case, just buttressed by this unassailable DNA evidence, it had to be transformative for the jury.
Oh, completely. They didn't have to wrestle with conflicting circumstantial accounts. They had biological fact.
So the deliberation process in 2010, it must have been quick.
Remarkably short, especially considering the 3 decades the case had already consumed. The verdict came back swiftly. Guilty on all 5 counts of first-degree murder.
And the penalty was, finally, definitively, death.
And this time, the verdict stuck.
This legal struggle that began when Jimmy Carter was president in 1980.
Finally concluded near the close of Barack Obama's first term in 2010. That 31-year span isn't just the duration of a legal case, it's the relentless operation of due process.
And at this point, we really have to reflect on the human cost and the immense resilience required to see this through.
Absolutely. Robin Samsoe's mother, Marianne Connolly. She endured 2 overturned convictions, 2 death sentences, the prospect of a 3rd trial.
She was 79 years old when the nightmare finally ended.
Her journey of perseverance is just a testament to the enduring human need for closure. I mean, can you imagine being asked to climb the same mountain of grief 3 separate times, only to be told each time, sorry, the paperwork was filed incorrectly?
It's unimaginable.
Her quotes after the final verdict are just profoundly moving. They capture this essence of release after decades of just waiting and waiting.
She outlasted him, at least in the courtroom.
She did. Her final words on it really capture what that victory meant. She said, "It's over. It's finally over. I can breathe now.
Wow.
I can visit Robin's grave and finally tell her, it's done, baby. You can rest. He can never hurt another child. That's all I ever wanted."
A statement of peace finally attained.
It really is. As for Rodney Alcala, he went back to death row at San Quentin. And despite the conclusiveness of the DNA evidence, the sources confirm he continued the only thing he knew how to do.
Filing endless, frivolous appeals.
For another 11 years. He died of natural causes in 2021 at the age of 77.
And he remained the definition of a controlling narcissist until the very end.
He died without ever expressing remorse, without confessing, without providing any closure on the full, true extent of his crimes. His final act was an act of non-cooperation.
Taking those answers with him.
Exactly. And when you look back, the 3 decades of courtroom drama reveal this critical dual legacy. On one side, you have Alcala's intelligence weaponized.
His use of the legal system, his manipulation.
His utter lack of empathy on display. He used the very system designed to protect him as a tool of endless trauma against his victims' families.
But on the other side, you witness this tenacious, dogged pursuit of justice.
The willingness of detectives, forensic scientists, prosecutors to just refuse to quit. And most importantly, the refusal of the families to be broken by a system that kept failing them.
They fought the labyrinth until they won a definitive victory rooted in science.
It's a really powerful illustration of the justice system's capabilities. When the evidence is circumstantial or procedural, the system errs on the side of caution,
leading to the overturns.
But when modern science provides the unassailable tools to move beyond reasonable doubt, the system can, eventually, deliver absolute certainty.
So, to bring this deep dive to a close, the legal war against Rodney Alcala isn't just a true crime case, it's really a foundational lesson in American jurisprudence.
It is.
We've seen how the legal system prioritized procedural fairness, which led to those multiple agonizing overturns, but how ultimately the revolution in forensic science provided the unassailable proof needed for final accountability.
And this history really emphasizes the necessity of the appeals process, even when it feels infuriatingly slow and insensitive to the public and the victims.
Right.
Those hurdles, those reversals in '84 and 2001, were the system's indispensable way of guarding against flawed evidence.
Whether it was hair analysis that was scientifically shaky.
Or informant testimony that was procedurally compromised. When the evidence was flawed, the conviction was reversed.
But when the science was sound, when the probability was 1 in 190 quadrillion, the verdict stuck.
It proves that while the path to justice can be long and riddled with technicalities, the system is designed to eventually deliver definitive results when the evidence is unassailable.
And that balance between speed and certainty, particularly in capital cases, it always leans toward certainty.
No matter the decades of delay.
And that leads us to the final haunting question that we want to leave you with. While the 5 murders were resolved in the 2010 trial, the prosecution was preparing to try Alcala for the full scope of his photographic collection.
Hundreds of images of young women, many of whom were never identified.
Alcala died in 2021, and that search for closure for those unidentified women, it continues. The question remains haunting. How many more victims might still be unaccounted for?
Their fate sealed in those boxes of forgotten photographs. It's a search that continues long after the legal battle ended and his life concluded.
A final, unwritten chapter of the shadows he cast.
It's a chilling reminder that even after definitive justice is served, the full measure of a killer's crimes often remains tragically unknown.